Please get ready for a dictation of exercise number 19 from the legal material. 5 seconds. Start. These appeals have been filed against the impugned judgment of the Andhra Pradesh High Court dated 30/4/2003 in writ appeal number 629 of 2003 and writ appeal number 584 of 2003. For the sake of convenience, we will deal with the facts of civil appeal. Heard learned counsel for the parties and perused the record. The facts of the case are that the respondents 1 and 2 in this appeal were appointed by the Andhra Pradesh State Road Transport Corporation, hereinafter referred to as the Corporation, as contract sweeper and attend on 1/5/1992, and respondent number 3 was appointed as such on 1/8/1992. They submitted representations to appellant number 1 and 2 for regularization of their services, claiming that they have completed 240 days of continuous service without any break. But since 10/5/1998, the appellants were not giving them work. Hence, the respondents filed a writ petition, being writ petition number 10678 of 1996, which was disposed of by the High Court on 17/10/1997, directing the corporation to consider the case of these employees for regularization of service. By order dated 31/3/1998, the representation of the writ petitioners was rejected on the ground that their regularization can only be considered when they are recruited through the prescribed departmental selection committee and after undergoing a selection process. Since they were not selected and appointed in accordance with the aforesaid procedure, their case for regularization could not be considered. Aggrieved, the respondents filed a writ appeal number 6948 of 1999, which was allowed by a learned single judge of the High Court. In the counter affidavit filed by the corporation in the writ petition, it was stated that the petitioners were entrusted the work of the attendant sweeper on casual basis on a consolidated pay drawn through a pay order on certification of the work every month, but they were not issued any appointment order. It was also submitted that as per the circular of the corporation dated 1/5/1996, there was no provision to engage anyone on contract basis or on consolidated pay. The writ petitioner had not undergone the departmental selection process, and as such they were not entitled for regularization. Learned counsel for the writ petitioner relied on the circular of the corporation dated 26/10/1988, wherein guidelines were issued to engage the existing contract labor such as cleaners, including piecemeal rated labor against the sanctioned vacancies. In view of this circular, it was contended that the writ petitioners were entitled for regularization. The learned single judge allowed the writ petition and directed regularization of the writ petitioners within 6 weeks. Aggrieved, the corporation filed an appeal before the division bench of the High Court, which was rejected by the impugned judgment. In our opinion, these appeals have to be allowed. It has been held by a constitution bench of this court in Secretary State of Karnataka and others versus Uma Devi and others that absorption, regularization or permanent continuance of temporary, contractual, casual, daily wage or ad hoc employees dehorse the rules and constitutional scheme of public employment cannot be granted by the courts. As regards the circular dated 31/3/1998, the same cannot override Article 16 of the Constitution, and hence regularization cannot be granted under the said circular. Stop.